argument, I will then call on them and they will ask the question. Is everyone ready to proceed? Appellant, please identify yourself for the record and let me know how much time you wish to have for rebuttal.
Good morning, Your Honor. Jeffrey Merman from Hinckley, Allen, and Snyder on behalf of the Plaintiff Appellant Metropolitan District Commission. I wish to reserve 5 minutes of my time for rebuttal.
I'm sorry, go ahead, please.
And with me in the room, socially distanced, is my colleague, Alexa Millinger, who is on the brief.
Thank you very much, counsel. You have your 5, whenever you're ready.
Thank you. May it please the court, the MDC brought this declaratory judgment action pursuant to section 52-29 to seek a judicial determination, 1, that the MDC can charge DEEP a remediated groundwater fee for liquid waste other than sewage, pursuant to a resolution adopted in 2007 in connection with discharges from the Hartford landfill into the MDC sewer system. 2, that the MDC has the right to change the amount of the fee. And 3, that the MDC has the right to refuse to accept discharges from the Hartford landfill into the sewer system. The complaint sought injunctive relief, and only injunctive relief, prohibiting DEEP from discharging from the landfill into the sewer system until the issue of the payment of the fee was resolved. Injunctive relief requiring DEEP to account for the $20 million it received from the predecessor manager of the landfill, CRRA, in 2015, and a judgment declaring that the MDC has the right to refuse to accept discharges from the Hartford landfill. DEEP moved to...
Counsel?
Yes.
Justice Doria has a question. Justice Doria?
Thank you, Chief. Attorney Merman, can you explain to me before DEEP took over the responsibilities of the landfill, the relationship between MDC and CRA was contractual? Is there a contract that was in the record, or are they just a paying customer that, do you just charge them on a pay-as-you-go basis, or what was the relationship?
It was contractual. The MDC entered into a contract with CRRA with respect to discharges into the sewer system.
And would the rights that you're suggesting you have vis-a-vis DEEP, that you want to go to court for the declaratory judgment on, would it be clear under that contract that you had the right to rejigger the fees and to stop them from allowing the leachate to go into the sewer system? The rights you're looking for, would that have been clear from the contract with CRA?
I believe the answer to that is yes, Your Honor, although that was not specifically alleged in the complaint, so it wasn't before the trial.
So we don't have that contract. We don't have that before us.
I don't believe you do.
Okay, thank you.
DEEP moved to dismiss the action on 2 grounds: sovereign immunity and failure to exhaust administrative remedies before the claims commissioner. So I wish to address 3 main points. First, it's clear that the state has waived its sovereign immunity. Second, this case is not simply a claim for monetary relief that requires exhaustion before the claims commissioner. Each count of the complaint, as well as the prayers for relief, make that clear. And third, there is no basis for concluding that the 3rd count, which seeks a declaration that the MDC can refuse to accept discharges into the sewer system from DEEP, is a claim for monetary relief. With respect to the first issue of sovereign immunity, there are 2 main purposes behind sovereign immunity. One is to protect the state from litigation that might be... Yes, Your Honor?
Yes, Justice Khan has a question. Thank you. Justice Khan.
Thank you, Chief. Attorney Merman, you said now in your introduction that both the claims or the counts in the complaint, but also by statute, the state has waived sovereign immunity and can be sued. I'm looking at page 5 and 6 of your brief, you, in response to your opponent's argument and to the court's finding, you say the court did not cite any support, factual or legal, for the finding. Nowhere in the complaint does the MDC state that its goal is to force DEEP to pay a higher rate. You go on to say, to the contrary, a fair reading of the complaint, from a fair reading of the complaint, it is clear that the MDC seeks only to resolve the dispute with DEEP, and for that reason seeks a declaratory judgment. What is the dispute? You don't define the dispute in your brief.
The dispute is whether the MDC has the right to charge a remediated groundwater fee. The dispute is whether the MDC has the right to change the amount of the fee. And the third issue in dispute is whether the MDC has the right to refuse to accept discharges from the Hartford landfill into the sewer system. And none of those, sorry.
So you defined a dispute as basically reiterating the 3 counts of your complaint.
Correct.
Okay. So as to that, even if we were to assume the 3rd count, which seeks the ability to stop accepting the sewage from DEEP, doesn't that also go to the heart of a collection case? Because what your complaint, unless I misread your complaint, even that 3rd count says we should reject the waste until they pay us the higher rate. So it all comes back to getting the higher rate. So how is that not about money? Whether it's the higher rate in the future or the higher rate of fees charged in the past? I'm trying to understand how every count in your complaint ultimately doesn't go back to an issue of money. Because you're not saying forever stop accepting their waste, just stop accepting it until they pay us the higher rate.
No, we're also saying that we can stop accepting the waste because, and this is found in paragraph 82 on page 842 of our appendix, that say that DEEP has alternative disposal options available to it. And so it's not just a question of money. Because DEEP has alternative disposal options, we believe we have the right to refuse to accept the waste.
Yeah, but that's not the point, right? The fact that they can bring their waste elsewhere, what you're asking the court for relief is just don't make us take their waste until they pay us a higher amount. So how is that not about pay?
No, we're saying don't make us take their waste until we resolve this issue of whether they should pay a higher amount. And indeed, any payment by DEEP in connection with this lawsuit would be prospective only. We're not seeking, unlike, say, in Bloom, where the plaintiff was seeking retroactive payments of unemployment compensation. This lawsuit makes no claim for money damages now or in the future. And to the extent that there would be future claims for money damages, we acknowledge that those claims would have to go through the claims commissioner.
Well, let me just put it differently. If in an ideal world, your opponent said, you know, you're right, we're wrong, we should pay you the higher rate, would you still have any counts left? Or would that resolve the entire lawsuit?
If DEEP were to say, you're right, and we agree that we should pay the higher amount, that would probably resolve the lawsuit.
Okay,
but
thank you, counsel. I'm going to let you finish. I just want to alert the chief that I'm done, and I see my colleague, Justice McDonald, has a question, but please finish answering my question, and thank you, counsel.
Thank you, Your Honor. The problem is that here, DEEP is saying it shouldn't have to pay a remediated groundwater fee for the introduction of pollutants into the system. It should be charged the domestic sewer rate, which is a rate charged independent of the discharge of pollutants into the system. And so the issue in dispute is whether DEEP should be subject to the remediated groundwater rate rather than the domestic sewer rate.
Thank you. Justice McDonald, and then Justice Ecker, then Justice Doria. Thank you.
Counsel, let me maybe ask it this way. Is the claims commissioner authorized to make the legal determination that MDC could charge the different rate to Deep before allowing a claim to go forward? I mean, I've just never heard of a situation where the claims commissioner, if Deep is correct, that the claims commissioner would have to resolve a legal question of authority of the MDC to charge a differentiated rate prior to allowing something to go forward in court. Do you know of any other situation like that?
I don't. The problem, of course, Your Honor, is that in this situation, because there's a statute of limitations on claims before the claims commissioner, the MDC had to bring claim past.
Sorry, I can't, I'm losing him.
Yeah, I lost him.
Mr. Merman, I can't hear you. I think his stream is frozen.
I'll stop the time.
Thank you. Recess in place. Could someone contact Mr. Merman and ask him to see if he can either reboot or have his IT people look at his computer?
I will try and reach out to him, Your Honor.
Thank you. Thank you very much.
You can hear me, then perhaps we can go forward.
Well, we couldn't hear you at all before. Now,
Okay.
if you just talk a little bit, I'll be able to determine whether this will work.
Sure. I think I was responding to the question regarding the authority of the claims commissioner.
Okay, so we can go back on the record. It's clear enough for us to make a good record. Madam Monitor, if we can go back on the record.
Oh, we're all set, thank you.
Thank you very much. Please continue, Mr. Merman.
Yes. So addressing the authority of the claims commissioner, one of the problems is that claims before the claims commissioner must be brought within 1 year statute. So couldn't get a resolution.
Mr. Merman, we're losing you entirely as far as the audio stream is concerned.
Yes.
Justice McDonald, if you can stop the time again, please.
I did. He may, could he call in on the phone conference ID number?
Mike can still hear us. Mr. Merman, could you do that?
I've called in, and I muted my computer, so hopefully we'll be okay.
That's working. Thank you.
Great.
Please continue.
All right, so I'm not sure how much the court heard, but claims before the Claims Commissioner must be brought within 1 year for money damages. And so we couldn't get resolution of the authority or the right of the MDC to charge the remediated groundwater fee and bring a claim for past damages before the Claims Commissioner without proceeding on parallel fronts. But it's clear that the case which is before the court today does not seek money damages retroactively. And the Claims Commissioner could decide its issue without resolving the question of whether the MDC is entitled to either charge the groundwater fee, and certainly the issue of the right to refuse discharges into the system could not be decided by the Claims Commissioner.
Thank you.
So,
hang on, Mr. Merman. Attorney Merman, there's other questions. I can't remember the order. I said it earlier.
I'll go ahead if I'm not sure who else is has their hand. Justice Doria.
No, go ahead. You
okay.
go ahead.
Okay, thanks. I guess I have a question on the third count, Mr. Merman. It's an interesting claim, and I'm not sure what to make of it. I was looking at, and maybe the analogy I have in mind is off point, so you'll correct me. I was looking at a case called 184 Windsor Avenue against the state. I don't think it's cited in the briefs. It's about a dispute between a landlord and the state tenant over a rent escalation clause. And I think the court held there that the landlord could not sue, that sovereign immunity prevented the landlord from suing under the rent escalation clause. And I'm wondering about the connection here. And more specifically, whether the landlord in that case could have sought to evict the tenant. Because essentially that's, at least by analogy, what you're doing. You're saying, well, if you don't want to pay for our services, find someone else. You have another option. And I guess I'm wondering whether that's prevented by sovereign immunity as well. I don't know if an eviction action against the state is within the scope of sovereign immunity, but maybe or could illuminate it by some other reference.
I think, Your Honor, in this situation, we need to make reference to the special act which created the MDC. And the special act gave the MDC broad powers related to sewage disposal, among other things, and permits the MDC to adopt ordinances with respect to connection with its sewers and to address discharges into the sewer system. So I think the broad powers given by the special act and the MDC's charter specifically authorize the MDC to reject discharges into the sewer system that it chooses to. And think about what we're talking about here. We're talking about discharges of pollutants that require treatment by the water treatment facility. And the purpose of the remediated groundwater fee was to provide payment to recoup the cost of treating those pollutants. So this is not analogous, in my view, to a lease situation between a landlord and a tenant, because specifically the special act and the charter give the MDC the authority to reject discharges.
Okay, thank you.
Sure. And just lastly, if the MDC didn't have that authority, then it could easily be overwhelmed with pollutants that it could not treat. All of those pollutants would then go into the Connecticut River. Justice Story, I believe you had a question.
Yes, thank you, Attorney Merman. Understanding that we really can't make much of, we usually don't make much of failed bills. Can you tell me just factually if the legislature has ever sought to settle this, resolve where where this would be litigated? Or the authority issue?
Well, I think, the special act, as I read it, the only reasonable interpretation of that act, or that special act, is to give the MDC the authority to both adopt these regulations and to enforce them.
Well, I guess I mean, I'm sorry to interrupt, but I guess I mean since DEEP took over the responsibility and started claiming sovereign immunity, has anybody sought to, I say that, I guess, a little bit editorially because, using public dollars to fight about where the forum is sort of, but I think you've answered my question. Let me ask you a different question. Is, when you, going back to my point about the relationship between CRA and MDC, would you have had to go to court to establish your right either to charge the higher fee and or to just refuse to take the leachate? I don't know how that happens, how you refuse to do that, but or would you just start doing that? You start sending them a bill, or you'd start saying, don't discharge that into the sewers?
I think it would start with don't discharge it into the sewers. To stop it, the commissioners would vote to adopt a resolution to reject the discharge, and then it would be shut off. And I think that's an important point here, because think about if the commissioners decided to do that in this case to prevent DEEP from discharging into the sewer system. DEEP no doubt would consider bringing a declaratory judgment action to ask the court to determine that the MDC didn't have such a right. So does it make sense to suggest that DEEP would have the right to bring a declaratory judgment action to address this issue, but the MDC does not?
Well, I think the state would think that makes eminent sense, but I'm sure you disagree. But just to be clear, you think you don't have to, you wouldn't have had to go to court. The resolution would have been enough for CRA to say, stop dumping this. You wouldn't have to go to court to establish your right to shut that off.
Mr. Merman, that's right.
Mr. Merman, you have 5 minutes.
I'm sorry, is this with respect to my rebuttal or?
No, 5 minutes in your main argument to go.
Thank you. Okay. Justice Story, have I answered your question?
No, so you just don't think, you think the resolution would be enough? You wouldn't have to go to court to resolve whether you have the authority to do that?
That's correct.
Okay, thank you.
Thank you. I'm sorry, were there any other questions that I've overlooked? I think I want to make mention of the court's recent decision in 777 Residential LLC versus the MDC, decided this past September. And in that case, this court recognized that the MDC does have those powers granted to it by the state, or that are necessary for it to discharge its duties and carry out its objects and purposes. In that case, the court considered what type of charge the MDC was permitted to make to the plaintiff. And here, DEEP claims that it may be charged only the domestic rate, not the remediated groundwater rate, and that's what we're asking the court to resolve in this case. I should make brief mention of the case of Glastonbury versus the MDC. which held that the issue of the right of the MDC to impose a surcharge on customers in non-member towns was independent of the issue of whether other legal remedies, such as the right for damages, existed. The point is that the question of whether this is a claim for monetary damages must be resolved independently of the question of whether it is barred by sovereign immunity. And that's just what the court did in Bloom. So here the court asks the MDC asks the court to enjoin MDC from discharging pollutants into the sewer system until these issues can be resolved, either by ultimate court order of agreement or agreement. The issue of damages going forward is prospective with respect to the charges to be employed. So under the analysis of Deep and the trial court, it can be argued that any action for equitable or injunctive relief might be considered a claim for money damages. For example, in an action for specific performance regarding a contract to sell real estate, the successful party is awarded the real estate. That's a claim for injunctive relief. But that party ultimately must think that the property will appreciate in value, and that party may ultimately sell the property at a profit. The injunction may ultimately improve the economic position of the party obtaining such relief, but that doesn't convert it into a claim for damages. And just like that situation, our claim for injunctive relief here does not convert it into a claim for money damages in the future, even though there may be an ultimate economic benefit to the MDC. And finally, with respect to the issue of the purpose of sovereign immunity, this is not a case that seeks to interfere with the functions of DEEP. This is not a case which threatens the economic viability of the state. And so,
Counsel, you have 1 minute. You have 1 minute left, and I think there's more questions.
Sure. Just the purpose of sovereign immunity is not thwarted by this litigation. So,
Thank you, counsel. Justice Kahn.
Thank you, Chief. Counsel, as I understand from reading the briefs, that since you filed this action in Superior Court, your client also has currently 2 cases pending before the commissioner, correct? 2 requests
That's
pending
correct.
before the commissioner. You've indicated in your briefs that one of those relates to getting money for the waste that's already been processed, sort of, back pay for the higher rate. But in order to grant that, whoever the ultimate decision maker has to make a decision that you're entitled to, that your client's entitled to the higher rate. So isn't that really doing this piecemeal? What if that action proceeds and a court says, you know what, you're entitled to the higher rate for the trash or the waste you've already processed, and then a different tribunal says, no, you know what, you're not entitled to a higher rate? Then we could have 2 conflicting decisions, right? Why is this being done piecemeal? Isn't there a risk of that?
I don't think so, Your Honor, for the
Why not?
following reason. Because if this court agrees that the MDC has the authority to charge the higher rate, that doesn't necessarily follow that the claims commissioner will permit the MDC to sue for the higher rate for past charges or for unpaid charges going backward. So I don't think that there is a fear of conflicting resolutions. The problem is that if the court doesn't conclude that the MDC has this authority, and the claims commissioner doesn't or if the claims commissioner chooses for whatever reason not to permit the claim to go forward, the MDC has no real relief that it can seek from the claims commissioner. So I don't think there's an issue of conflicting possibilities.
Thank you very much, counsel. Your time is up now. You can add a grace note if you'd like.
No, I think I've said enough for now. Thank you.
Thank you. Counsel, are you ready to proceed?
I am, Your Honor. Thank you very much, and good morning. May it please the court.
Before you start, though, can you see Justice McDonald? He's our timekeeper.
I can see Justice McDonald.
Okay, thank you very much.
I'm all set. Thank you. Good morning, Your Honors. May it please the court. My name is Daniel Salton. I'm an Assistant Attorney General of the State of Connecticut, and I'm representing the Department of Energy and Environmental Protection in this underlying matter. If there's any technical issues, of course, please feel free and let me know. This case is a fundamentally very simple one. The Metropolitan District Commission has brought an action that, while labeled with injunctive and declaratory relief, is in actuality, and has been conceded in oral argument again today, fundamentally about getting the state to pay the rate that it wants and to pay out money to the MDC. Because the MDC in its complaint has not alleged a valid exception to sovereign immunity, the dispositive issue here is only whether or not such an exception exists. And in the absence of a valid exception, regardless of the nature of the complaint, the MDC's action is blocked by sovereign immunity and should be dismissed for lack of subject matter jurisdiction. I see that questions have already begun. I'm happy to stop and start taking them.
Thank you, counsel. Justices, I was looking down at some paperwork, so I didn't see who rang in first.
Justice Doria is should go first. Go ahead.
Thank you very much.
For me.
I no longer see Justice McDonald. Has he disappeared from the?
Oh yeah, he has.
Counsel Chief, he indicated he had logged out momentarily, is logging back in. He got kicked out, but he's back in.
All right, so if we can just recess in place. Okay.
I think Chief Justice McDonald had a question first.
I don't have a video stream from Justice McDonald at all, but Justice McDonald, can you hear me?
I can. Thank you. I got kicked out.
There you are.
Counsel, let me ask you, the prayer for relief makes it very clear that they're not asking for money damages. The statement of amount and demand makes it clear that it's only seeking a declaratory judgment. It may be that the ultimate goal is money, but that's not the relief that a court could grant in this case as framed by the plaintiff. The plaintiff is constrained to the relief it has requested, and it has not requested money damages. So it may be a step in a process, but it's not the entire process. How can a trial court look beyond the scope of the complaint before it to conclude that there is something else motivating this case?
Your Honor, the answer to that is it comes in several pieces. So first, when a trial court or this court is examining the pleadings for the purpose of sovereign immunity, as articulated by our appellate court in Bloom, which this court cert denied, and of course in St. George, Cluin, and Daimler Chrysler, the court scrutinizes the pleadings to see whether or not the ultimate result of the pleadings would be monetary relief. And in this case, when we look at the actual prayer for relief, what is asked, and as my brother counsel conceded in this case, what is asked is not for a determination of legal rights, but coercive elements in order to induce payment of the fees from the state to the MDC, which is a form of monetary relief. And moreover, Your Honor, and I think it's very, if you look specifically at paragraph 83, if we're thinking about specifically that third count, paragraph 83 of the complaint found on page A31 of my appendix indicates that the dispute between the parties is with respect to whether the MDC may refuse to accept discharges from the Hartford landfill into its sewer system, should DEEP continue to refuse to pay the disputed fee.
No,
and
I understand that, counsel, but maybe let me ask it this way. Yes. At the end of the day, in this case, could a trial court enter a judgment in favor of the plaintiffs for $25 million? Does it have the authority to do so?
It could not, Your Honor, but by concluding that a fee is legal and legally valid or could be legally increased, as this court has held in Pamela B. and in Sentner, because declaratory judgment actions are, of course, binding upon the state and the state is bound and obligated to follow them, the state would be compelled to then pay the fee, because this court has concluded that our good faith dispute with the MDC, articulating that we don't believe the fee is legal, is wrong, and thus we're bound to pay out as a result.
Of course, the flip side of that is that if Deep won in this case, that would be the end of the discussion. It seems to me that this is not very different than a trial court as a management technique bifurcating a trial to determine whether or not liability even exists first before it hears any evidence about measuring damages. Why is this any different?
The fundamental difference, Your Honor, is that unlike a standard bifurcation or unlike a standard action between two parties, sovereign immunity doesn't just implicate liability. It also implicates our immunity from suit. The state should not be obligated to defend actions in court that it has not waived its immunity on. And regardless of whether or not this is declaratory or monetary, ultimately, the dispositive issue here is whether or not there is a valid exception to sovereign immunity. Because even if these were all declaratory and injunctive requests, at the end of the day, a litigant still does not get to come into court directly against the state and just commence a declaratory or injunctive action. They must allege one of the three valid exceptions to sovereign immunity. And in this action, the plaintiff has only alleged one. That is, that there's a legislative waiver of that immunity, which would apply regardless of whether it's monetary or non-monetary.
All right, I have other questions, but I'll hold off while my other colleagues ask theirs.
Justice Daria?
Yes, good morning, Mr. Sultan. Why isn't the 2013 Act the waiver of sovereign immunity? Why isn't the act of the legislature directing Deep to take over, and I'm quoting, you shall enter into a memorandum of understanding requiring the department to assume all legally required obligations resulting from the closure of the landfills? I mean, if you're taking over all legally required obligations, don't we look to what those obligations are and how they would be resolved?
Your Honor, I think that first, although that says it does require us to take over all legally required obligations, it obviously does not explicitly say that the state's immunity is waived as a result of taking over operational control of these landfills. The question is that a necessary implication in the legally required obligations? And the answer to that is, of course, no. We can take over CRA's obligations, that is to, ensure that the discharges are properly, released and held pursuant to state law, that we have the obligation to maintain control of the leachate inside the landfill, all of our statutory obligations. That doesn't flow from there that we are thus waiving all immunity as regards to the landfill. And notably,
well, let me ask you this. I take your point, but I mean, you say this is a simple question. In my experience, I don't know of a situation like this where, but remind me, because I've forgotten a lot of it, I'm sure, where usually somebody is looking for the authority to sue the state just ab initio. But here there was a relationship. And unless you have a different position, MDC could have gone to court as against the CRA. So you're not necessarily just talking about a waiver of sovereign immunity. You would ask us to construe that special act as divesting the MDC of the authority to enforce its contracts the way it always did. I mean, if this was a private actor, that would probably have some sort of interference with contract type claim. I'm not sure how that works out with the quasi-public, but you can respond to that.
Perhaps, Your Honor, that is possible, but it's worth noting a couple things. First, the MDC, despite saying that there's a contractual relationship in oral argument, didn't plead such contractual relationship, right?
Okay, but there's got to be, I mean, Mr. Sultan, it's got to be a matter of public record if it is or it isn't. You know,
I mean,
your client would know. Your client would know one way or the other if there was a predecessor contract.
I agree, Your Honor, that there is likely a predecessor contract. But whatever that contract or relationship may have been between the CRRA and the MDC as a quasi-public and a municipal corporation, what the MDC is arguing here is that by virtue of the legislature affirmatively coming in and taking something under state control without explicitly waiving sovereign immunity, that private entity that is now no longer a private entity, but is rather a state entity and in the hands of the public, is not protected by the guise of sovereign immunity, even though it's not like we affirmatively went out and, sought to maintain its private status.
I guess this is the last thing I'll say for you to respond to, but it may not be as specific as usual sovereign immunity waivers. It's incredibly general for DEEP to assume all legally required obligations. I mean, I don't know what that means except everything.
Well, Your Honor, if it is ambiguous, if it's not clear, then EnviroTest does provide the answer, which is even if the legislature is being unclear or ambiguous, the court is bound to construe it against a waiver of sovereign immunity. Because the idea is that a necessarily implied waiver of sovereign immunity, and I'm quoting EnviroTest here, is when it is the only reasonable way to read the statutory scheme. And I note further, Your Honor, that EnviroTest itself sort of directly contradicted and cautioned against the idea of construing contractual relationships between the state and a private entity as a waiver of sovereign immunity, cautioning that under such circumstances, it would basically destroy the doctrine altogether.
Unless, I knew I said this, unless the legislature authorized you, the commissioner, to enter into that contract. And that seems to me to be what's happening here. I'm pointing towards my screen. That you're directed to enter into an MOU to assume all legally required obligations.
But, Your Honor, unless that MOU, and I don't think that MOU could even contain a waiver of the state's sovereign immunity, Your Honor, because our office cannot waive the sovereign immunity. The executive cannot waive sovereign immunity. Only the legislature can do that. And in this case, where the legislature is, at best, unclear as to what their intentions are in terms of legal obligations.
I thought EnviroTest said that the legislature could authorize an officer to waive sovereign immunity contractually. It's just that they didn't.
I'll concede, Your Honor. I'm not absolutely positive without the case in front of me.
Okay.
However,
thanks. You've answered my questions. Appreciate it.
Thank you. So,
Justice Ecker.
Thank you, Chief. These questions, or I have two questions, one of which follows from what the colloquy that you just engaged in, and maybe it's been answered in that, I don't know, but I would ask it a slightly different way. As I understand it, the DEEP has been paying these fees before. There has been payment of fees in the past, and the issue now is at what rate, right?
Well, the disagreement is that a new charge, Your Honor, was imposed upon the DEEP. It was basically replaced one charge for the other. DEEP disputed that charge, and thus a claim was filed from the claims commissioner.
I guess my question is, if the payments were being made, were the prior payments were being made not as a matter of grace, but as I understand it, as a matter of legal obligation, whether pursuant to an MOU or the statute requiring the arrangement, but they were being paid as a matter of legal obligation, right?
They were being paid, Your Honor, pursuant to an agreement as part of the permit issued to the CRRA. When the MDC approved of the discharge into its system, it indicated that a certain charge would be charged against it in a letter.
So my question is, if there's a legal obligation, why isn't it enforceable in court?
Well, it is enforceable, Your Honor, through the claims commissioner. That's the venue when you're seeking to enforce a legal obligation for money against the state. If this was a breach of contract action, the expectation, if you're seeking to enforce that obligation, that money would be go to the claims commissioner.
And that goes, I guess that goes to my, I get it. I get it. And you've answered that question. It goes to my second question then, which is, this is really a dispute about a renegotiated rate or a new rate or a enhanced rate or something along those lines. And I guess my question there is where would the remedy lie for the MDC? I mean, the claims commissioner doesn't have the ability to renegotiate the contract. And if the court doesn't have the ability to adjudicate the propriety, the legality of the rate, then it would seem like the MDC is just stuck.
I would assert, Your Honor, that the claims commissioner does have, as part of its evaluation of whether or not a claim is just or not, the ability to evaluate whether or not such a legal obligation would lie. In fact, 184 Windsor Avenue, which you cited earlier and is in fact cited in my brief, specifically evaluated whether or not a lease escalation clause was legally valid, and the claims commissioner concluded that it was not. And this court, Justice Norcott, writing for the court, indicated that the claims commissioner correctly concluded such, and that such, of course, bars the claim and bars it under, bars any claim, on the basis of sovereign immunity. So the claims commissioner.
I just have one more question, and I just am getting through it just so because I know my colleagues have questions too, and I don't mean to cut you off. I'm sorry for being rude. Does a landlord have the ability, notwithstanding sovereign immunity, to evict the state tenant?
I think, Your Honor, that will depend explicitly on statutory schemes, not before. I cannot say with certainty. There may be some waiver somewhere in our statutory scheme, but the standard rule is that in the absence of one of the three exceptions to sovereign immunity, someone cannot bring an action in court against the state, period. Right?
Okay, thank you.
They may seek non-payment of rent through the claims commissioner, right? But, unpaid rent through the claims commissioner. They may seek, if there's a valid legislative waiver for landlord-tenant, perhaps, but not just against the state as a matter of a standard action. I'm sorry, Justice McDonald, I see you have a question.
Thank you, Counsel. Justice McDonald.
Thank you. So I have one question that I'm going to approach from two different angles. And that is, if this went to the claims commissioner and the claims commissioner determined that there was no legal authority for the MDC to charge a differential rate as a legal matter, could the MDC appeal that?
Yes, Your Honor, they could appeal it to the General Assembly, like they could any other claim brought before the claims commissioner that's denied. The General Assembly could waive the sovereign immunity and allow them to bring the action.
No, I'm not asking them waiving the sovereign immunity. I'm saying if the claims commissioner made a legal determination that there was no legal authority for the MDC to charge a differential rate to DEEP, is that an appealable issue?
It is not, Your Honor, but it would be determined as part of a denial of a claim, concluding that said claim is unjust and thus sovereign immunity bars it. Thus, the remedy that the MDC would have under those circumstances is to go to the legislature, say we disagree with the conclusion, we ask the Assembly to waive the sovereign immunity, allow us to bring our action, and then it comes into court, and they can, litigate that issue to the full extent in front of a court once sovereign immunity has been waived.
Okay. Now let me ask the question in the inverse: if the claims commissioner made the determination that there was legal authority for the MDC to charge a differential rate, would the state still be able to argue that there was no legal authority once it went to court, or is that legal issue been resolved?
I don't believe it would be considered binding, Your Honor, because it is merely a determination in both circumstances as whether or not the claim is just pursuant to 4-160. A trial court, once the action is commenced, permission to sue is granted. The trial court can evaluate then that same legal issue as a matter of law. Of course, it will put the state in a far less beneficial position in arguing that because we have the reasoning of the claims commissioner to essentially run against. But the claims commissioner's determinations are purely on the basis of whether or not a claim is just for the purpose of sovereign immunity. And then there would be of course, action of whether or not, as a matter of law, we are obligated to owe them once sovereign immunity has been waived.
Right.
So they are distinct but interrelated.
Okay. In the absence of seeing any of my colleagues asking questions, I'm going to keep going for a second. I want to go back to the original issue that I brought up with you, that a declaratory judgment action is intended to help resolve the relationship between parties where their juror relations are in doubt. How is that not exactly what is here?
Because, Your Honor, context in this case is king. Because the relationship in doubt here is that we will not pay the MDC the money they demand. And as my brother counsel conceded to Justice Khan, at the end of the day, if we said, okay, we'll pay the money, we're going to pay the damages you demand.
Wait a minute. I'm sorry to interrupt, but you were paying an old rate.
Yes,
you disagree with paying a new rate. And so you don't doubt, you're not contending that DEEP is not obligated to pay. It's just whether there is legal authority for the MDC to charge a differential rate.
What we're contending, Your Honor, is that the new charge imposed upon us is not legal and not valid, or arguably we could argue that even if it's legal and valid, it may be unconscionable. There's a number of merits arguments that we might raise under those circumstances.
Fair enough,
but
that's a DJ action. That's exactly what a DJ action is intended to accomplish.
But at the end of the day, Your Honor, when we look at what, for the purpose of sovereign immunity, this court's precedent and Bloom indicate that regardless of what is claimed, if the ultimate result of the action is monetary relief from the state, then it must be treated as an action for monetary damages, right? That's why in an unemployment hearing in Bloom, which arguably is about the ascertainment of benefits, it was treated as monetary damages. In Daimler Chrysler, it was a tax rebate order. In St. George, it was about a question of indemnification, right? Even when there's no certainty that such damages will flow, this court and the appellate court has treated it as monetary. And in this case, because what flows from such conclusion is that the state must pay the MDC X dollars going forward, going backwards, then it is and should be treated as a monetary action. Thank you, Your Honor. I'm sorry, Justice Soria, I see you.
Thank you.
But is it necessarily so that that flows the monetary relief? I mean, if we take Attorney Mermin at his word, or I guess construe the complaint in a way to see if anything survives sovereign immunity, it could be that when it's resolved that yes, they have the authority to charge the rate, then the state doesn't have to pay it. They can go off and find a different way to discharge the leachate. And that Mr. Mermin is saying he'd be perfectly happy with. And then, you don't have to fight about whether to pay for it or not.
Right. Your Honor, the problem with that is that Pamela B. binds us to comply with the conclusions of a declaratory judgment. If the declaratory judgment says this is a valid charge and you are obligated to pay, then we are obligated to pay. We're obligated to pay going backwards as well, because the declaration of this court or a lower court is we're on the hook for that money. And thus,
well, I mean, maybe you might be right, but there is some difference between prospective and retroactive monetary relief. It could very well be the case that the court could say, I don't have authority to, this is where we're really attacking the public fisc, is we're going to charge you retroactively. That's the intrusion, is the public fisc. But if we're just declaring what the rights are, state, you can figure out how you want to order your affairs going forward. Pay for it, don't pay for it, discharge it, don't discharge it. You decide.
I would point out, Your Honor, our jurisprudence has never made such a distinction for the purpose of monetary relief and sovereign immunity. Notably, St. George was indemnification in the future, right? Bloom was was a future unemployment hearing. Daimler Chrysler was arguably retroactive, but Cluin, which I didn't ultimately touch upon, would have been prospective, right? And I would point out further, Your Honor, and you can see this on page 837 of my appendix. If you look at the claim in this case, it's not just asking for past damages. It's past and ongoing damages all the way into the future. And thus, the claims in this case are present claims that encompass future non-payments and past non-payments. No distinction has been made by the MDC in this case as to the monetary relief, right? And no jurisprudence has ever held that there is a distinction. The only case they cite is Pacini, a Superior Court case talking about 11th Amendment jurisprudence for the purpose of 1983 actions and determining whether or not the Commissioner of Revenue Services was a person pursuant to a 1983 action that has been sort of ultimately replaced by our court's analysis in Miller. And as this court has held in Miller, monetary relief, period, implicates sovereign immunity and must be only found through the first exception. I'm sorry, Justice Khan, I see you've raised your hand.
Thank you, counsel. Justice Khan.
Thank you, Chief. So my question is, it's sort of a follow-up to the line of questioning that Justice Doria and others have asked you. Let's assume this lawsuit could go forward. Let's assume that the court or the trier of fact determines that, in fact, your client must pay that higher rate. Is your position then that, based on the contract that exists, that your client still has to have its waste processed by the MDC, meaning you don't have the option, as Attorney Mermin suggests, to go outside of that?
It is not even contractual, Your Honor. It is, in fact, a bindingly legal permit pursuant to 22A 432. Which is that because we are obligated under state environmental law to maintain and control discharges from landfills that have, leachate impact, the state must discharge that appropriately. And the permit in this case, the one that was sent to the CRRA and was approved by the MDC and is now still, binding on the state that as it's taken over operational control, requires said discharges to be discharged into the authority designed to treat said discharges, namely the MDC, whose legal authority and responsibilities are to treat wastewaters of the state, right?
So the answer to my question then is, if this lawsuit were to go forward, let's assume the claims commissioner authorized it and it were to go forward and you were to lose the claim, then your position is it is about money, because at the end of the day, you can't go elsewhere to process this and you would have to pay that higher rate and then would have to pay it going backwards, as in arrears, but that going forward, you don't really have a choice but to go through MDC and to pay that higher rate. Is that what you're saying?
Until there was a new authorized permit issued to discharge in a different way, until some other method was developed, we cannot just allow the landfill to overflow. In fact, one of the greatest concerns of this complaint is that they're essentially asking the court to seal off the landfill, thus creating incredible environmental harm, in order to exact payment, to twist the arm, to force a concession, because under our state obligations, we must control discharges from the landfill. And thus, we would have to keep that in control. And that goes back, to Justice Doria's question earlier about the idea of, well, can't the state, would the state bring an action if they simply turned off the tap? The answer is, obviously, we could bring environmental enforcement actions. We'd have a number of options under those circumstances, none of which, of course, would waive our sovereign immunity regardless, because of the Computers Plus decision, which says that if we bring enforcement actions on behalf of the public, that does not flow that our sovereign immunity is waived. And I think the real key point here, Your Honors, is what has been asserted by the MDC is that pursuant to their sue and be sued language in their charter, and pursuant to I have the ability to enter into a contract language in their charter, it is necessarily implied that there's a waiver of sovereign immunity for all these claims. That's the only exception alleged. It's the only exception argued. And as we have briefed, neither of those pass the EnviroTest standard. It is not required as part of a general power to sue and be sued that the MDC must be allowed to sue the state, nor is it required if they wish to enter into contracts, which specifically in that portion of their charter 1-2B speaks to renewable energy resources and not generally. Nor is it required that they be allowed to sue the state in the event the state becomes a successor in interest to the thing that they contracted with the CRRA. That's a multiple leaps of logic in what was specifically delineated by the legislature. And though the legislature did indicate that we are to pick up our legal obligations, that language does not definitively indicate a need to waive our sovereign immunity. At best, at most, it is ambiguous. And EnviroTest is clear. If it's ambiguous, it is not a waiver. If there's any other way to read it other than a waiver of sovereign immunity, it is not a waiver. And that is ultimately the dispositive point of this case. This is a case where the MDC filed a claim in the Claims Commissioner for money. They're not happy with how that process is taking, and they're making an end run around the Claims Commissioner by bringing essentially the same claims here, covered in injunctive and declaratory relief. And as this court knows, using that old analogy, calling a bull a cow won't change its gender. As Bloom said, merely calling something declaratory relief does not make it so when the ultimate result is going to be monetary impacts against the state. For all of these reasons, Your Honor, the trial court's decision should be affirmed, and this case should be dismissed for lack of subject matter jurisdiction. Thank you very much.
Thank you, counsel. Attorney Mermin.
Thank you, Your Honor. I'd like to start by addressing Justice Kahn's question about does DEEP have an alternative to disposal? And the answer clearly is yes. I'm not sure if this came up in the complaint or in briefing, but DEEP can dispose of the waste by other means. It can truck it off-site. It's not bound to keep it on site, but it has an alternative to discharging the waste into the sewer system of the MDC. In this case, we are seeking prospective relief only. And what's interesting is that the trial court could conclude that the right of the MDC to charge a remediated groundwater fee is prospective only, not retroactive. Bloom makes clear that what is prohibited is a claim for retroactive monetary relief. And in that case, it found that the claim for unemployment benefits, which had previously been denied, was what was at issue. And so that was what the plaintiff there was seeking, was retroactive monetary payments of old unemployment compensation claims.
Mr. Mermin, there are questions.
Certainly.
Justice Kahn, Justice Doria.
Thank you, Chief. Yes, Attorney Mermin, I raised my hand when you answered the question that I had raised with your opponent. You say there are other options. They could take truckloads of from the site. If they were to do that, if they were to say, fine, we're not going to use MDT, your services, would your client go back to court and say, hey, you're required to do this?
No.
By permit?
No.
You would be perfectly willing to let the business go away, if you will.
I'm not certain, and I might be speaking out of turn, but my memory is that the cost of treating this waste exceeds the amount that would be paid even under the remediated groundwater fee.
But that's not my question. My question is, you said it's very clear they have other options and they could do that starting now, take truckloads of the waste elsewhere. And my question to you is, if they were to do that, would your client have a valid claim for like a breach of contract or an obligation to have your client process the waste? Do they have to seek permission from the legislature? And so that's my question. After that, I know Justice Doria and Justice Ecker also have questions. So if you could just answer that question, are you sure that they could just do that without getting permission from the legislature or without running into problems with the contract or MOU or understanding they have with your client?
I'm reasonably sure of that.
Counsel, you have a minute and a half left.
Thank you.
Justice Doria?
Yes, thank you. Attorney Merman, so what do you say to Attorney Sultan's point that if we take you at your word and you say, well, I only want prospective declaration that I can charge this fee, and if the state goes elsewhere to dump it, that's fine. But if you're going to litigate whether they should have been paying for the last few years up until that gets declared, Mr. Sultan's point is that he's bound by that, his client's bound by that. Are you going to seek to enforce that rate because it's now been declared? How would you relitigate that?
I'm not sure I understand, Your Honor, but if you're saying that...
I think you're admitting that you'd go to the claims commissioner for the retroactive. But if a court has already declared that you have the right to charge this rate, and you're saying, I'll just take that relief prospectively, and the state can go on its way if it doesn't want to pay it, how is the claims commissioner to do anything other than say that this is the legal rate?
The claims commissioner could say that it's the legal rate. The claims commissioner could say that the MDC has the right to sue for the past obligations, or the trial court, and then ultimately on appeal, this court could say that the right to charge is prospective only, not retroactive.
Okay, thanks.
Thank you.
Counsel, I know your time is up, but I know there are more questions.
I'll be happy to answer them.
Thank you, Justice McDonald. Justice Ecker?
I'll try to make this quick. Justice Doria raised the possibility in questioning opposing counsel that there had been possibly a waiver of sovereign immunity under Public Act 13247, Section 236. And since he didn't ask you, I'll ask you. I didn't see that claim being made in your brief or argument. Is that correct, that claim has not been made? I confess to having no memory of making a claim. That doesn't mean I didn't, but I don't remember it. So. Okay, thank you. No other questions.
Thank you. Attorney Merman, you may do a very brief wrap up. Thank you.
I don't really think that I need to address anything more except to say that as Justice McDonald pointed out, I think it's critical that the court take a look at the prayer of relief on page A43 of the appendix, and it's clear that this is not a claim for money damages. It is a claim only for declaratory judgment, and I ask the court to reverse the judgment and decision of the trial court and to remand the case back to the trial court for further proceedings.
Thank you, counsel. I want to thank both counsel for doing this matter virtually. As you can see, we had some technical problems, but we were able to work them out. I appreciate everyone's patience. And with that, we will be adjourned until tomorrow.